Welcome to When Family Matters Become Legal Matters.
Welcome back to When Family Matters Become Legal Matters, where we're here to help you navigate legal steps needed to protect your family, your future, and your legacy. I'm your host, Evan Mack, and I'm joined by Miss Betsy Holton, founder of Holton Law Group with years of experience guiding families through estate planning, elder law, and special needs planning. Betsy is here to share practical advice and trusted strategies that turn complicated legal issues into peace of mind. This is episode 4, special needs planning, ensuring lifelong support for your child. It's interesting that this is the topic. My brother, he's autistic, and it's one of those things where he's special needs. He's older now, and my mother's getting older, and I'm older, and he's into this kind of mode where we're trying to put things in place for him to be able to be sufficient, while also trying to give him his space to be, the man that he is. But when it comes to that, can you talk to the people that might be dealing with the same thing, but why it's so essential, with a family that has someone that's a dependent? Why is that planning so important?
So, Evan, I think the important thing for us to remember is that the Special Needs Trust is a special trust that the IRS, the Social Security Administration have allowed families to put in place to provide for an opportunity for the individual who has special needs to grow and invest funds, but not be in a position where they're not receiving their special benefits from the government. That's a little complicated, so let me try to break it down. Basically, if you are receiving government benefits, they are expecting you to have very low assets. They're expecting you not to have a huge chunk of money sitting away, and then they're providing you with benefits. But because most individuals who are on, say, the autism spectrum, or they have medical needs that prevent them from being able to be gainfully employed, they can also receive Social Security and Medicaid, and we consider them special needs. So they don't really have the ability to go out and work and accumulate funds. So, how can they have the quality of life that they should be able to benefit from, but for the Special Needs Trust? So, that was one of the ways that it was created. So, here's what it does: it allows you to put assets away. They aren't counted when the Social Security or Medicaid agencies go in and do their benefit analysis. So they're not counted, and they get to stay. In most states, there is a pooled trust, which is made up by many individuals who happen to have special needs, and they all put their funds into that trust together, and they're segregated out for the individual, of course, but you'll have someone able to manage those trusts. But there are families who do have their own individual special needs trusts that allow them to manage the funds directly. But because it is an irrevocable trust, it also becomes a credit shelter trust. It also becomes a trust that allows for expenses to be paid out for things that the government would not have paid for. For instance, it would allow you to pay for extra medical equipment or medical procedures. For instance, I know individuals who may have problems with their mental health issues. Well, a lot of times the Medicaid is not going to cover any type of treatments that are not medically necessary, but they may be a little cosmetic. So you'll be able to have money set aside for that. It allows for recreational activities because, of course, the government is not going to pay for someone to go on trips. But if you want to put money away for your loved one, for instance, my daughter loves to cruise, then she can participate in the family trips just like everyone else because there's funds available for her. And then it's also a great place to allow funds that if you have insurance policies, you want to make sure that if something happens to you and you're caring for the special needs individual, that you can provide money for them that won't cause them to lose their benefits, and you can put that money aside into the trust. It grows, and then even though you're not here, there's a trustee in place who can still provide for those same extra activities that the person would have been able to benefit from if you were still here.
What kind of problems can a family run into if they kind of leave their an inheritance directly to the special needs
Oh,
individual?
yeah, and so in many instances, it can cause them to lose their benefits. And there's
Wow.
another instance that comes up, not only just leaving the money to them, because even though it's a lot of people, well, my insurance isn't taxable to my beneficiaries, but it becomes a new asset that they have. The other thing that happens is sometimes they can be involved in an accident or there may be a lawsuit involved. Well, if you're not very careful and you don't have seek legal advice on how to receive those assets, you can lose your government benefits. So you don't want to ever be in a situation where you experience a windfall, even if it's not an extremely large amount. It could cause you to lose your government benefits, and you have to go back and go through the whole process and reapply all over again. And it can create a mess because, of course, you're receiving medical treatment on a regular basis,
Hmm.
and then all of a sudden it has to stop because you've eligible for the Medicaid and the medical care that you're able to normally get. And you either have to pay for that out of pocket for a period of time, or you have to not receive those benefits. That's not an optimal situation. So anytime you either plan to leave assets through an insurance policy or through any other type of transfer, or if there's going to be a lawsuit that affects the individual who is receiving the government benefits, you clearly want to seek legal advice to make sure that those assets are sent to the correct type of either special needs trust or some other vehicle so that the individual remains eligible for the benefits that they do receive.
I'm curious about guardianship or conservatorships, like the arrangements, how do they play into long term planning?
There are two things about the guardianship and the conservatorship that's important. One of the things is we talked about the special needs trust, and that
Right.
only handles the finances. So when you have an individual who may have cognitive deficits, they're many times they're not really able to manage their everyday living activities. I think they actually have a special name for that, daily living activities, DLAs.
Yeah. Yeah.
So, yeah, and so you want to have someone who's able to be responsible for making sure that those things are taken care of, making sure that if they have housing, making sure that their rent and their utilities are paid, making sure that if they need assistance with someone coming in to provide housekeeping services or things of that nature, you have someone taking care of all that. Well, when you are not in a position to well, if you're in a position where you can do that yourself, you typically don't need someone to help you. But
Right.
typically, if you're suffering from the cognitive deficits, you can't make the decision to appoint someone to handle that for you. So a lot of times you have to have a guardianship or a conservatorship, depending on the state and the name. You would have to have that in place so that there's someone in charge, because everybody needs to know who they're supposed to deal with.
Yes.
They when they walk into that situation, you know, they're not going to be able to communicate with the special needs individual, especially on a level that can conduct business, because they typically, they're not there. So you have to have someone in place. Obviously, it's optimal if you were able to get that done during that transition from them being a minor to becoming an adult. But
Mhm.
there are some times where that may not even manifest itself until after the individual has become an adult. And so, of course, as much as you would like to, you are unable to do it without court intervention. Now, again, I think we talked about this in another episode about how going to court sometimes becomes a long, drawn out proceeding. It doesn't have to be always, but it is necessary when you have an individual who is an adult but cannot make their own decisions. You have to place someone in charge. And so guardianship or conservatorship is something that can help with that process. Now, the guardianship and the conservatorship can be covered in a trust. It's a very technical and very intricate type of process that we go through. But the problem is when we set up trust, generally, the individual who is the grantor, the person who owns the items that they were placing into the trust, who owns those assets, that person is signing off saying it's okay to place those items into my trust and it's okay for my trustee to make these decisions for me. Unfortunately, when you're dealing with someone who has cognitive deficits or someone who can't make those decisions, they're not able to sign off on those things on their own. And so we are required to go through a court process to have the court name them. And so name someone to do that. And so it's important that we follow those rules and understand that that becomes a task that the guardianship or the conservator has for the benefit of the legal term is the ward, the person who is incapacitated. So that requires doing annual reports to the court about both their well-being and their assets if they have any. And it requires you to do what is in the ward's best interests at all times. It creates a fiduciary responsibility for the person who has been appointed by the court.
You've talked about, different processes through this, and it is important, but it can feel overwhelming to people. What can you give the people at home, like, what's one thing families can do today to begin planning confidently?
Yes. So if you have an incapacitated or special needs individual who is a child under the age of 18, speak with legal counsel to put together a special needs trust before they turn 18. If you're able to do that, then you're able to reduce the chances that you'll have to go to court at a later date. If you are dealing with an individual who is already over the age of 18, then it's important that you at least attempt to get the special needs trust in place to handle their finances if they have assets, and then going ahead and consulting with an attorney about setting up the guardianship or the conservatorship so that everyone has the right legal documentation to deal with all the third parties that may come into play. Um,
Well,
these doctors, some of the other facilities, apt to want to have absolute legal documentation before they make decisions, before they provide treatment, before they allow admission. So all of those things are very, very important to have in place because we don't want to delay treatment. We don't want to have a situation where the individual doesn't have a place to stay with their loved ones. You just don't want to create those extra headaches for the family. Once you get the process started, it really isn't very difficult in it. And once it's in place, it's it's a beautiful situation because you already know who's going to make the decision. You already know how conflicts can be handled. It's a great way to get everything started.
how often should special needs plans be reviewed or updated, as people's, like, circumstances evolve? Is there a set limit? Can they just set it and forget it, or is there something else they should worry about?
Yeah, with all of our planning processes, we would never suggest that you set it and forget it, because in general, everybody can experience changes in their situation. So it is typical, especially in my firm and some of the other estate planning firms, that we set up plan reviews. We typically do a 3-year review. And we go through and we sit down with the client and we take a look at any types of changes. People get married, people die,
Right.
people have children. And so we automatically set those, but there is a conversation that's had at the time that we complete training. I mean, that we complete planning and we do our signing to say, if something happens, don't feel like you can't give us a call, because it's important that the plan work. We can draft a beautiful plan, put it in a beautiful binder, but if it doesn't work when you need it, it's almost useless. So we definitely want to make sure that if we put a plan in place, anytime we notice that there's a major change in the family, there's a major change in circumstances, that is the time that you contact the attorney to make the updates and changes to your plan.
Awesome. Thank you so much for taking the time, Miss Betsy.
Thank you.
And thank you all for listening to When Family Matters Become Legal Matters. If today's conversation was helpful, be sure to subscribe, leave a review, like, share, and show someone who might need it. For more resources or to connect with Miss Betsy Holton and the Holton Law Group team, visit HoltonLawGroupFL.com. If you're in Texas, DFWTrustandWills.com. Your family's future is too important to leave to chance, and the right plan can make all the difference. Thank you so much for watching.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.